in its response to the review of the Foreshore and Seabed Act 2004.
The Honourable Chris Finlayson.
Today the government released a public consultation document outlining the government's preferred approach and seeking feedback from the public on each aspect of that broad framework and the various options within it. The current Act has proved to be anything but an enduring solution. Significant numbers of New Zealanders have complained and continue to complain that that Act is unfair and discriminatory. It's important that we find an enduring solution, and so I'm very much looking forward to hearing what New Zealanders have to say.
The Hon Tau Henare.
Mr Speaker, how is the government responding to the review panel's report of 30 June 2009?
The Honourable Chris Finlayson.
The panel advised repeal and enactment of replacement legislation. The government's carefully considered the report, and in the months since the panel reported has been engaged in an extended conversation with iwi representatives and other interested parties. The government's picked up and is consulting on a number of the panel's recommendations, including repeal of the Act, protecting public access, removal of formal Crown ownership, providing for recognition of customary title and restoring the fundamental right of access to the courts.
The Honourable Parakura Horomia.
The Prime Minister say that people would see little change because the government's preferred option is really just to repeal and reenact the current law.
The Honourable Chris Finlayson.
The previous Act, or the current Act I should say, does not include that fundamental right of access to the courts so that people can seek justice, and that's what caused so much ill feeling in 2004, and that's what we're trying to address.
Rahui Katane. Order. I've called Rahui Katane.
Thank you, Mr Speaker. To the Minister, how will the government avoid making the same mistake identified by the Ministerial Review Panel in 2009, which characterised the former government's decision to legislate as unacceptably interventionist, overriding the option of allowing the judicial process to take its course and thus removing the right to due legal process?
Honourable Chris Finlayson.
Mr Speaker, well, the most important thing I think we can do as we contemplate repeal and a new enactment is ensure that any reform recognise that fundamental right to access of justice that all New Zealanders have.
The Honourable Tau Henare.
Thank you, Mr Speaker. What consultation will the government be undertaking during April this year?
The Honourable Chris Finlayson.
Mr Speaker, over the next month I'll be attending quite a number of hui, I think it's 11 hui, and numerous other public meetings throughout New Zealand. The aim of these meetings is to consult with interested parties on the government's proposals for reform. Following that consultation, I'll be reporting to Cabinet, and final Cabinet decisions can be expected in late May and June, and I'll tell Mr Horomia where I'm going to be in Gisborne because I'll look forward to his positive participation.
David Garrett.
Supplementary to the Minister, to the Attorney-General. How is the government solving the problem by recommending that no one owns the Foreshore and Seabed and establishing an entirely new legal concept, takiwa iwi whānui, the legal meaning of which can only be determined in the future through case law?
Mr Speaker, there are essentially four options. There's absolute Crown ownership, which is what the previous government tried, which was unacceptable.
Point of order.
I didn't ask the Attorney-General what the options were. I asked a question on whether or how one of the options that has been recommended by the government could be solving the problem. I didn't ask for a list of the options.
Speaking the point of order, the Honourable Simon Payne.
The Attorney-General had barely got the first option out. I'm sure, knowing him, he was preparing a well-crafted answer directly in respect of the question asked and giving it the context that he usually does.
Order. In fairness to the member who feels his question wasn't being answered, I invite him to repeat his question so that everyone can be absolutely sure exactly what he asked and listen to the answer with interest.
How is the government solving the problem by recommending that no one owns the Foreshore and Seabed and establishing an entirely new legal concept, takiwa iwi whānui, the legal meaning of which can only be determined in the future through case law?
Honourable Chris Finlayson.
Because Mr Speaker, there are a number of options and the member doesn't want to hear the detail of them, but the government considers that the public domain concept is a very sensible way of proceeding to deal with this issue and providing a stage post where customary title can be investigated.
David Garrett.
Will he legislate to guarantee public access to the foreshore and seabed? And if not, why not?
The Honourable Chris Finlayson.
Mr Speaker, the answer is yes, and public access was never legislated for before the 2004 Act, and one of the aspects of that Act was that it made it clear beyond peradventure that there is public access, and those provisions confirming public access will be carried over.
Question number 4, the Honourable Ruth Dyson.
Thank you, Mr. Speaker. My question is to the Minister of Health.